All right, everybody, we will go ahead and get started. It is 10 a.m. For those who don't know me, my name is Andy Cole, and I'm the Pro Bono Coordinator at West Tennessee Legal Services. Thank you all for joining our first Pro Bono Month training. We are talking about conservatorships today. Just a few housekeeping things before we get started. You all should have received an email that has a link in it to a form to request your CLE credit on it. That email also has a Dropbox link in order for you to be able to access the materials and training for this training. And this is also being recorded so that if anybody needs to go back and look at the training for anything, or if you miss any part of it, you can go back, and it will also be available for CLE credit when it recorded. If you have any questions, feel free to ask those in the chat. We'll be monitoring those. I believe Elizabeth has some breaks scheduled in to be able to answer questions that we have. So we'll get those to her during those time. The other announcement that we have is that we are launching at West Tennessee Legal Services a new project on conservatorships. Several of our chancellors have agreed to allow volunteers to appear virtually for uncontested conservatorship cases. So if you're interested in doing that, on the CLE credit sheet, there is a way to sign up for it. This will be huge to be able to help a lot of our clients who live in our most rural counties and don't have the ability to pay for an attorney and just don't really have access to many attorneys in their counties. So this will give them that opportunity to be able to get a conservator. But Elizabeth, I will go ahead and hand it over to you.
Thank you, Andy. Can you hear me okay? Oh, Andy's off now.
Yes.
Okay, good. So, thank you. I'm, like Andy said, my name is Elizabeth Duke, with West Tennessee Legal Services. Before we jump in, how do I get to the next slide? There we are. I just want to do a little quick overview of who we are. West Tennessee Legal Services is a nonprofit civil legal aid organization that we help underserved individuals throughout 17 counties in West Tennessee. So if you're not familiar with legal services across the state, there's really kind of 4 major legal aid. There's Memphis Area Legal Services, there's us, then there's Legal Aid Society in Middle Tennessee and the Cumberlands, and then East Tennessee. So we cover the 17 counties. Our metropolitan county is Madison County, where Jackson is located, and then the 17 counties surrounding. So we cover physically an area larger than the state of Massachusetts, providing access to healthcare, kind of what the slide says, securing, retaining income, securing and retaining housing, which is a really, really active unit, securing, I'd say security from abuse, not security of abuse, and institutionalized persons, and issues that affect family and safety, kind of domestic violence advocacy work. So quick disclaimer, my position here at West Tennessee Legal Services is funded primarily through 2 federal sources, the Legal Services Corporation and Title III funding of the Older Americans Act. So the information contained in this presentation is for informational purposes only. And the opinions that come out of my mouth are my own and do not reflect that of Legal Services Corporation, the Health Human Services Department, or West Tennessee Legal Services. So I just have to say that, because we all know that sometimes things come out of my mouth that may not be correct. So I also would like to just share a little about myself. I am the senior services attorney here at West Tennessee Legal Services. I am a newer practicing attorney, and I want to say that the information that I am providing here in this presentation today is based on my experience working with legal aid in rural West Tennessee. And so this means, while I'm going to touch on all the requirements, the lens that I am presenting through is that of a legal aid attorney who works in rural West Tennessee. And so I'm going to go through kind of best practices, things like tips, things I've learned along the way. But I by no means am claiming to be an expert. But really, like Andy said, conservatorship requests in our area are becoming more and more frequent. And I know that's not just our area, it's across the state. And one of the purposes of this CLE is to educate potential pro bono attorneys who would be willing to accept cases, even potentially long distance, and so we can meet more of our community needs. We're finding anecdotally that we're seeing small town businesses like clinics and banks are being purchased maybe by larger companies. And so families that have been able to get by without the legal paperwork, kind of taking their maybe adult disabled child to the doctor or to the bank, used to be able to work without the paperwork. Well, now these companies are being maybe bought out by bigger companies, and we're finding that they're coming to us saying, hey, we've been able to get by for the last several years, and now we need the paperwork. And so and I think that combined with kind of high profile news cases, Britney Spears, Michael Oher, is creating kind of a national awareness that conservatorships exist. So we have these things compounded, but it also means that there's kind of a misunderstanding of what conservatorships are, what they entail. And so that's what we hope to kind of break here today. So our purpose is to not just educate you, but to try and meet the community needs at large, and then really kind of continue promoting an awareness of conservatorships and what they entail. I was going to, and I don't know if I can do it. Let me see. Launching a poll. This is the first time we've done the poll in the Zoom. And so if you see it, it seems that people are participating. So that's good. And I should have said, if you have questions, feel free to throw them in the chat. Andy's going to watch it for me. I cannot be looking at a chat and speaking. I'll lose my mind. So if you have questions as we're going along, make note of them, throw them in the chat, and then Andy will ask. And like Andy said, we have one official scheduled break, but we can answer those. So a decent number of West Tennessee, some Middle Tennessee, some East Tennessee, and then some Memphis. I love it, love it, love it. Okay. So while we're doing those, I guess I have to end the poll before I move forward on my slide. Oh no, there it is. Okay. Alrighty. Share results. There you go. So now I guess you guys can see that maybe now back. Cool. So just to kind of give you a roadmap of the direction where we're going, a brief overview of the history of conservatorships, talking about what is a conservatorship, requirements of the petition, the role of the petitioner, the role of the proposed conservator, not always the same, and who are interested parties, your duties as the attorney, ethical considerations, as well as looking at roles and responsibilities of both the guardian ad litem and, in rare cases, the attorney ad litem. I will say, Andy, get ready to throw a link. If you can throw that Conservatorship Association of Tennessee link in the chat, that'd be great. Currently there is no state oversight of conservatorships. And so I'm going to give a shout out to Amy Willoughby Bryant. I think she's on this. She's out of Davidson County and just a conservatorship guru. And so she maybe should have been presenting this, but I appreciate that she's here, but she's done the work and actually called all the county clerks throughout the state of Tennessee to ask how many conservatorships are active in your county, how many, and theoretically, according to the statute, the clerks are supposed to know this. And there's a handful that do have an active list and could tell her an exact number. There's a great deal that can give her an estimate, and then there were several that just had no idea. And so that's problematic, right? So the conservatorship is a legal stripping of rights of a person. The court ordains this, right? That the court orders this. And according to statute, the court is also supposed to keep track of this. So it seems that there's maybe some movement on the state level to try and make that happen. But if you are at all interested in continuing learning your conservatorship, learning, getting engaged, connecting with people who are involved in the conservatorship process, the Conservatorship Association of Tennessee they have newsletters every week. Next month they have an all-day training in Nashville. And so I would encourage you to get connected with that organization. So now we'll do another poll. Let's just check. I'm gonna launch this. This one says it has 2 questions. First question, it says untitled. That's my fault. Have you filed conservatorship cases? And I'm just doing this to get a gauge. Have you ever filed? Have you filed one? Have you filed a few? Have you never filed? And then the second question is if you've ever served as a guardian ad litem or an attorney ad litem. And again, just kind of getting a sense of who's on here. So we've got a good mix, and I appreciate that. So, okay. Thank you for that. So, I'll share this results. Ta-da! Okay, now I'm gonna stop sharing. Go away. Okay. So what is a conservatorship? That is why we're here, right? What is a conservatorship? As an aside, I tried to get a local clerk involved. She's really good, also an attorney, been a long time clerk and master. But she had a doctor's appointment, so she couldn't come today. But I said, well, what is one thing that you would like attorneys to know? And she said, I really wish attorneys would read the statutes. And it's kind of funny because it's our job, but I'll be upfront. I don't always remember to go back and just confirm what the statute says, especially if it's something that I feel is fairly routine. And so our conservatorship, according to our statute, is a proceeding in which a court removes the decision-making powers and duties in whole or in part in a least restrictive manner from a person with a disability who lacks capacity to make decisions in one or more important areas and places responsibility for one of these decisions in a conservator or co-conservators. I think I'm supposed to be responsible, but so I guess one of the big takeaways you want to take from this is that the conservator statute, that you want to be really digging into that when you're going through your process. And conservatorships are very case-by-case basis, fact-specific. It's not something that should be considered like a stamp and just move it on. And so the statute really does have a lot of information that can help you kind of gauge how you need to approach your situation. So in the process of preparing this, I had to, consult Google because that's what it is. And I thought it was very funny to just see what Google was suggesting when I think I typed in like history of conservatorships. And this is the first thing that came up, right, when it suggests all of these. When did conservatorships become a thing? Why was Spears put under conservatorship? Have any famous men been under conservatorship? And it's interesting. These are the questions that very generally Google thinks I'm going to ask based on what other people ask when they're searching. And so I thought it was worthwhile to just kind of get an overview, big overview, and then we'll look into Tennessee, and then we'll focus on our modern statutes. My background, by the way, is history. I am a history nerd. I am not going to apologize for it. I am who I am. But I think the idea of reviewing the history of conservatorships will help us kind of see the potential for problems or potential for issues that might arise in our dealings with this in any of the future conservatorships. Unfortunately, kind of woven throughout the history of conservatorships are the themes of power and abuse. And that's just the history. We can't change it. It is what it is. But I think this is an important thing to remember as we wade through modern conservatorship law. So the earliest form of conservatorships is found in Roman law. The conservatorship itself was the embodiment, honestly, the embodiment of the patriarchy. And I mean the patriarchy in the literal sense, right? If you're familiar with Roman law, if you're familiar with kind of Roman society, fathers, the male was the head of the household, the male was the head of the government, and everyone else fell in line underneath that. So it was that patriarch, right? So the male patriarch was in charge. And so the male could have a guardianship, we call it conservatorship, but a guardianship over maybe children or women who were not married, who had property. And that was to keep the property under the male, the patriarch's possession, right? Because he was in that society in charge. We will see that replicated, kind of that Roman model replicated in early United States. Early case law in Tennessee shows that the law viewed anyone who was basically not a cis white male as someone who lacked capacity, especially when dealing with property. So you might be familiar with some of the old-timey legal language. A femme covert meant if you're a married woman. It literally means female covered. And so she is covered by her husband. If a woman became widowed, but she owned property, like she inherited her husband's property, she was not viewed, generally in American society, and especially in Tennessee, this is how it is. She was not viewed capable of managing her own property. And we see, and so there were guardianships over widowed women until they were married, and then the new husband would take over that property. Even more troubling is when we look at, here's my women, when we look at people of color and the manipulations that happen. There was a case, and I'm planning on digging more into it, but it's from the 1820s, and it was a woman of color who claimed that she was free, a free person of color, and the basically slave catchers were trying to say, no, we need to return her. And she actually had issued a writ of habeas corpus, and the court essentially decided, well, you don't have the capacity to make decisions for yourself because you're a woman, because you're a person of color, and so we need to put a guardian over you. And the guardian basically said, well, turns out she's actually enslaved, and so in the process of trying to fight for her freedom, a conservatorship actually pushes her back into slavery. And that was kind of a widespread theme if we see. So we're looking at women. We're also looking at, if you're looking at language, if you're trying to search these types of cases, the language that was used in the 18th and 19th century would be idiot or lunatic, lunacy. This is people with disabilities. This is how society referred to them.
Back started. I apologize for that. Elizabeth, you should be good to go. But you're muted.
Thank you. All right, so thanks for everyone's patience. We don't know what just happened, but it seems we're back on track. I was saying that 18th, 19th century, we were looking at the various people groups that were being impacted, and the final one that I just want to touch base on is that of the Native Americans throughout the United States, that guardianships and conservatorships throughout the United States were used, unfortunately, in ways that basically just pulled rights away from natives, swindling land away from tribes, taking children away from their parents. And there's a long history, unfortunately, long history of people who were placed in the role of conservatorship, ultimately to use that to their advantage. I'm saying all of this just so that we're aware of where if you're working in this field, where it's coming from, right? These are the origins of of how this worked. But the majority of our clients that are seeking assistance with conservatorships have legitimate needs. And the conservatorships do serve a purpose today. In the early 1990s, the Tennessee legislature created the first statutory scheme for conservatorships and guardianships in the state of Tennessee. And I'll say our state refers to when the proceeding is over an adult, over someone over the age of 18, it is a conservatorship. When it is someone under the age of 18, it is a guardianship. And I say that we are going to focus on the adult side, right? We're focusing, this one is on when the person has turned the age of majority, because there has to be basically a separate CLE for guardianship proceedings. It sounds like it used to be a possibility to get things in line to launch the conservatorship proceeding prior to a child turning 18. Unless I might be missing it, we file. I mean, if you're looking to try and get a conservatorship over an adult disabled child or a person who's about to turn 18, we file on the day that child turns 18, and that's just because the way that the conservatorship statute is written, it is the person with a disability is a person of the age 18 who has an alleged disability, and so it doesn't say under 18. That person has to be a person over the age of 18. So theoretically, there are safeguards in place, and this is going to be another poll that I have. I think this one's supposed to be a multi-poll, but what safeguards do you find, do you think are in place to protect people from unnecessary conservatorships? And this is open. You can choose more than one answer. So just kind of thinking through what safeguards. And yeah, I'll give it another minute and kind of think through. All right. All right, I'm going to end my poll. I'm going to throw in any more. And now I'm going to share the poll. Yeah. So, there was no right answer. I wanted everyone to kind of think through that. Oh, we're doing it one by one on here. Okay. The safeguards in place. So this is a legal stripping of excuse me, it's the stripping of legal rights of an individual, right, of a human being. And so we need these safeguards in place for, let's do that. Right, so just make sure that there's not inappropriate conservatorships in place. So family, there's required notice of family, at least the immediate kin, if you will. There is a requirement of a physician reviewing the respondent to confirm that there is an actual disability. The law itself is structured. If everyone's following the law, it's structured to try and protect, to make sure that there's no unnecessary conservatorships, and attorneys following the law are kind of another safeguard. I saw in the list, lots of people, like that was the first response. Lots of people said, well, guardians at Litem and attorneys at Litem, that is their job. That is a huge part, right? So they're kind of the guardians at Litem are the independent investigators that are just making sure that everything's on the up and up. Clerks, court personnel, judges all play roles in making sure that everything is appropriate, right? So it seems to me, depending on who you're interacting with, every clerk's office is a little bit different. Some are like my best friends and some are my mortal enemies. And but they all mean well, right? They have a job that they have to do. And so those clerks are making sure that, right, if that everything is on the up and up as far as the filing goes, that nothing's going to slip by. And then I would say the community at large, generally, generally, I don't think people want to see another person's rights be taken away from them, right? That's not what we want. And so there should be kind of an awareness of what a conservatorship is, and its purpose, just at large. And that's the big question, is it enough? And this is why we want to continue to create this awareness. So I have a series of considerations that I'm just kind of thinking through. If you're presented with the case, whether you're presented as going to be the petitioner's attorney, if you're presented as a GAL or respondent's attorney. But really, the first consideration when you're filing, who is your client? And that's a big one. And especially in cases when there's elderly involved, like a family member or a disabled family member, because there might be a lot of people kind of involved, right? Maybe the daughter called to say, hey, mom's struggling and I need to help her. Well, who's your client? You also want to think through, what is your retainer and your agreement outlining your duties, because the conservatorship process, and we'll talk about this later, is not just, it doesn't just end when the judge issues an order. The conservatorship, when the proceeding happens, a conservatorship is appointed, right? So it's in place, but then there's forms to file after the hearing. There's an annual accounting requirement. And when the conservatorship is terminated, whether it's maybe because the person passes away, or they rehab, they get better, they don't need it anymore, there's other proceedings in place. So as an attorney, you need to be mindful of what is your role and where do your services end? Is this going to be contested? And if so, by whom? So generally, we don't take contested conservatorships, but generally we're not getting cases. We don't get a lot of contested conservatorships that come our way anyway. Usually they're oftentimes legitimate family trying to take care of family. But in the event that there's maybe money is often a reason why something might be contested, disagreements on how mama needs to be treated, what have you. Something that just kind of need to keep on your radar as far as before the filing, even before talking to the client. Is this going to be contested? Every county is different. Where is this going to be filed? Is it going to be in your probate or is it going to be in your chancery? And then local rules. So when I get a conservatorship, when I see one coming across my desk, one of the first things I do is just call our local clerk of where that county is. And we're going to talk about jurisdiction here in a minute. But I always call and I ask, how much is it going to cost? Do you handle conservatorships in chancery or probate? Is there a special way that the judge or chancellor appoints the guardian ad litem? Because it varies, right? We specifically here have 17 different counties. I call one county and they'll say, no, we have a list we'll pull from. We assign the GAL, and then I'll call another county and they'll say, yep, just give me someone, and that's fine. So you want to confirm with that. Are there special forms that the judge or the clerk prefer to file, or do they have? And actually, if you go in that Dropbox, I'll say Weakley County, their clerk has a packet that they require that all people filing conservatorships get. So Regina Van Cleve is the clerk and master there, and she got it from Rutherford County. So just giving credit where credit's due. It's a lot of good information. A chunk of it doesn't really apply for our clients, indigent clients, but it is helpful, I think, information for just kind of the duties for a conservatorship. That chancellor has a specific language that he prefers in when he has the doctor's note. So you want to call your clerk and just say, do you have special forms that you want? Do you have special language that the chancellor prefers? And then how do you prefer issuing letters of conservatorship? And this is just for your information. At the end of the whole thing, some clerks are going to do it all by themselves. They take it and they move it forward. And some clerks are going to ask you to just bring them and then they'll issue them, right? And that's just how it is. And then same with the notice of hearing. So you're going to collaborate a lot with your clerks in conservatorship cases. So on the front end, you just kind of want to get an idea. If you haven't done it before, just be upfront about it and say, hey, this is what I'm doing and here's some questions, and can you help me? Because there is a lot of back and forth in conservatorship cases. Continued, Just be mindful, even again, before, if it's an intake type thing, something comes across your desk, what is the alleged disability? How long has that respondent had the disability? Was it triggered by something? Was it an event that triggered the disability? Has it been a lifetime worth of this disability? Is it possible, can rehabilitation or therapy assist the respondent with the disability? Is it something that is not permanent? Is there an alternative to a full permanent conservatorship? We're going to talk about that later. Is the respondent a veteran? We're going to talk about that later. This is a big one. Just talking to your client, which is often your client is the petitioner / proposed conservator. So if your client is calling and saying, hey, I need to get conservatorship over my mom, she had a stroke, she can't talk, she can't take care of herself, you need to talk to this person about kind of what a conservatorship is, how the proceeding itself, kind of what it's going to entail. The fact that the proceeding means that we're taking away the legal rights of her mother and that she's going to be in charge of those legal rights. And I think when you kind of explain that to people, like, this is a serious thing. It's not just a piece of paper. This is an active, serious thing. And that it's not something that just happens in a proceeding and you move on. You're going to have duties as a conservator. Just really kind of weighing the seriousness, kind of providing the seriousness of this. And I've had more than one client call me and tell me they've interacted with attorneys before and figured out they couldn't afford doing a conservatorship, only to call and talk to me and had no idea even what they were getting into. And so it's just, you just want to make sure that the client knows fully kind of the seriousness of what a conservatorship is. And then the question, who is going to be best to serve as a conservator? I, on more than one occasion, have had, it's usually mothers who will call and are concerned about their adult children. Maybe it's an appropriate conservatorship case, maybe it's not. But if they're telling me that they're scared of their children, if they're scared of their son's going to hit them, it doesn't seem to me that they would be a good conservator. And so that's something that we have to talk through, right? So a conservatorship is not a magic wand that forces people to do things. It's a way to help assist a person, but it's not going to just change a person. It's not going to force that person to start acting right. So if you're not familiar, there's not a lot of resources in Tennessee to assist if there's not family willing to serve as conservator. But there are some options, and that's something that if you have questions about that, kind of, if they come up, feel free to reach out to me. I would say the resource, the Tennessee Association of Conservatorships, is a good resource as well. To just kind of see what kind of alternatives there might be if someone does need a conservatorship, but the immediate family member doesn't seem like the appropriate one. Now, Andy, if you will, please go ahead and put that practical link, the ABA link in there in the chat. So while Andy's putting that link in the chat, I'll say the ABA a while back had put out this decision-making tool. There's on the website has a little bit of information, but there's a downloadable, there's a fillable PDF and a Word document that you could download. And they both have kind of worksheets that work through this practical, I don't know who did this. They're not, it should be, in my mind, that all of the letters should spell out on the front end, but they just kind of pick letters throughout and then they were able to spell out practical. But you can see here, it says, presume conservatorship is not needed. That is your presumption. That is what the court presumes at the beginning, on the outset of a conservatorship case. That is what you presume as an attorney. Let's just start with, we don't need a conservatorship. What are our options? Clearly identify the reason for concern. What is that? What is the reason for the concern? If the concern is my child is out and doing drugs, that's not the reason for concern. Conservatorships are only appropriate if they have no ability to make decisions for themselves, not if they have the ability to make bad decisions for themselves. Ask if a triggering concern may be temporary. That is so important. When was the last time your mom saw, right, someone who's maybe seems like she's a little out of her mind? When was the last time she saw a doctor? A lot of people don't know, but a UTI in an aging person, one of the symptoms that presents is actually, the person acts like they're out of their mind. It impacts their brain. And that's just a UTI. You get them on antibiotics and then they're back to their old self. They don't need a conservatorship. So what's going on here? Was it maybe a spouse passed away recently and they're dealing with depression? Is there a triggering event, and this is only temporary? And determine if these concerns can be addressed by community resources. There are all kinds of community resources available to aging and disabled individuals, vulnerable adults. If you're not familiar, there are the AAAD offices, the Tennessee area agencies on aging and disability. And all throughout the state, there's 9 different offices throughout the state that you can could touch base with, and they can assist with potentially if food's the issue, if getting on healthcare is the issue, if housing is an issue. They are kind of in place to help connect people seeking resources. They're a broker of resources is maybe the best way to put it, right? They can connect people with things that they might need without necessarily getting a conservatorship in place. And it kind of doubles on that. Ask if the person has already a team to help make decisions. Are the family members helping? Who's doing the work right now? Identify the person's abilities. Maybe it's not necessary to have a full conservatorship. Maybe a partial conservatorship is all that's necessary here. So let's make sure we're not stripping away unnecessary rights. Screen for potential challenges. Appoint a legal supporter consistent with person's values. So screen for potential challenges. I think that's kind of what I said earlier, looking at is it going to be contested? What's in the way, right? Just kind of think through what's going on here. And the legal supporter consistent with person's values. I think that's important, right? Remembering that in this whole process, the respondent is still a person, and they may not be able to communicate to you what they want, but they're still a person. And so we're wanting to make sure we're doing what's in their best interest. And then the big one, limit any necessary conservatorship petition. So again, when we're identifying what the need is so that we are limiting our petition to only address those needs, right? So if they only need help maybe managing finances, but they're able to get by living day to day, they don't need that their person rights taken away, then make it so that's the case. All right, so don't strip everything away. And if you're going to remember anything out of this whole situation, we are remembering that in the statute, the least restrictive alternative is the standard. And that has been the standard since the 90s, least restrictive alternative. So regardless of how you approach your conservatorship cases, if you use the practical tool by the ABA, if you create your own form for evaluating, you're still wanting to make sure that it's the least restrictive alternative. Okay, so who's who in conservatorships? We are looking at the petitioner, and that does not have to be the same person as the proposed conservator. It can be any person that has knowledge of the circumstances. It can be an entity. It can be historically DIDs, right? Actual agencies could step in and be the petitioner. The respondent, and so that's who your client is, right? And so if you're a petitioner's attorney, your client's not the respondent, your client is the petitioner. It gets kind of murky because oftentimes the proposed conservator and the respondent are often very much so together. But your client is still the petitioner in this case. The respondent, historically, the word ward was used. I'll use respondent throughout this. Tennessee has set up conservatorship proceedings as adversarial. So it's the petitioner versus the respondent. And then there's the proposed conservator. Again, they don't have to be the same as the petitioner. The conservator is the court determines the best interest, but there is a priority list in the statutes that the court shall consider. And if the court kind of deviates from that list, the court needs to identify in the order why they deviated from that list. And you can put a co-conservator or a successor conservator in your petition. I'll have to say this multiple times because even though I say it multiple times to my clients, it still happens to be an issue every now and again. But there is going to be doctors or psychologists are going to be involved in this. And your doctor has to be an MD or DO, licensed in the state of Tennessee. It cannot be a nurse practitioner. And unfortunately, I can say that and say it and say it, and I still will have someone return the documents to me signed by a nurse practitioner. It has to be a medical doctor, like an actual MD or DO. And then there are interested parties. And this is kind of one of those wonky things about conservatorship proceedings, is that it's required to notify certain entities or people related to this individual, but they're not named parties, right? They're not named to the suit. And this is something too, when we're looking at kind of the whole of the conservatorship statutes, they'll point you in kind of different directions. One of the places they point us is actually to the intestate distribution. So the way the statute reads essentially is next of kin. But if it's not a parent or a child or a sibling that's available, beyond that, you just have to state in your petition, there are no other immediate family. You do not have to try and like find extended family. But you do have to look in that order of what the intestate distribution, kind of which goes first, parent, child, or sibling. And really, at least the way I've handled them, they're not parties to the case until they file something appropriate, right? So maybe a sibling comes in and says, wait, I don't want you to do this to mama. Like, that's cool. And the judge is certainly welcome to hear them. They're not a named party until they file accordingly. So the filing, I think this is where like maybe conservatorships kind of get a little bit of a bad rap, like, there's so much going on. Checklists help. I have a checklist pinned, like just make sure you have all of these documents. When you're going to file, just to open up a conservatorship, you're going to need a petition, and it has to be a sworn or verified petition. That means your client signs it and it's notarized. There is going to need to be a sworn medical statement if it's available. If it's not, we'll talk about that later. And whether or not it needs to be notarized, we're going to talk about that later as well. There are going to be printed search records of registries, and I have some examples here in a minute. We'll talk about that. A document, willingness to serve document signed by your client, a proposed GAL order ready for the judge to sign. A notice of hearing if required. Again, you're going to find that out from your clerk on the front end, and then be ready with those filing fees if you don't have an affidavit of indigency, depending on who your client is. Thinking through where to file. Big question. It sounds very silly, but I've had already 2 cases where the respondent was not a U.S. citizen. And both times we ended up moving the case along. We couldn't take the case. The inquiries, I guess, are not real cases, but the question, can a judge legitimately strip the legal rights of an individual who is not a U.S. citizen? You can write that brief. I'm not going to, but just be mindful that those cases do come up. The petition is going to be filed in the county of the person with the alleged disabilities residence, right? So wherever they live, and there's the argument is wherever they live, if they can't move, they can't willingly move somewhere else. So wherever their residence is established, that's the county where it needs to be established. However, if that person with the alleged disability is incarcerated, the place where they are incarcerated, that Department of Correction facility is located, it's that county. Or if they were involuntarily hospitalized in an institution of the Department of Health and Substance Abuse, wherever that institution is located, it's in that county. So those are the 3 potential counties, right? So you're looking at essentially where is their residence. If it is not physically where their residence is, it's either where they're being held incarcerated or where they are involuntarily hospitalized. And again, I mentioned this before, you want to find out, depending on the county, it might be a probate matter and it might be a chancery matter. So you'll want to call and find that one out. requirements of the petition, I'll shout out back to that clerk. Just make sure you're reading your statute. Just make sure there's not been an update. I've done it. I've found like, oops, there's a big thing. Even going through here, like, oh, I forgot. I didn't know this. So, and we do have in the Dropbox, I think there is a petition, like there's some draft petitions that are blank with kind of the information on here to kind of help kind of set you on your way. But the name, date of birth, resident, and mailing address, if they're not the same, of the respondent, that's the person with the alleged disability. The petition must be notarized, like sworn by the actual petitioner. There needs to include a description of the alleged disability, and then the petitioner's name, age, residence, and mailing address, if it's not the same, their relationship to the respondent, and a statement of misdemeanors or felonies. If they have had a misdemeanor or felony, even if it's been expunged, it needs to be said somewhere in there. Maybe, and it does not automatically exclude them, but candor to the court, right? You need to tell the court, this is what's happened in this person's life. It's not going to impact them serving as a conservator or as a petitioner in this case. Proposed conservator needs that same information: name, age, resident, mailing address, their relationship to the respondent if it's not the same as the petitioner, also a statement of misdemeanors or felonies. But they will also require, the state now requires, as of I think 2021, you need to print off copies of, you search the Tennessee Health Abuse Registry list, make sure they're not on it, and the National Sex Offender Registry lists. Those are going to disqualify the person from being a conservator if they happen to be on these lists. And that applies to co-conservators. So if you're petitioning the court to have two conservators, the co-conservators, all of this information needs for both of them. And I just print it off. There's ways, if you're not familiar, if not savvy enough, you can go into your printer settings, make sure it includes the website address and then the date you printed it. But as it turns out, I'm not on the Health Abuse Registry. I did this yesterday, and nor am I on the National Sex Offender Search. But you want to print those documents off and include those with your petition to just show the court that the proof that the conservator is not in violation of the statute. Okay. We talked a little bit about the interested parties already. Notice is required, and it can be served by mail, right? So you have to look to the rules of civil procedure on service by mail. You're going to send it certified mail to the interested parties that are required to be listed. And again, that intestate statute, you only have to pick the first level, whatever that is, right? So if it's parents, you only have to pick the first level. If it's children, it's only to pick the first level. If there are no living kin in those three kind of levels, then you need to state that in the petition. If the respondent is being held in its institution, the institution needs to be notified. They get a notice. And then once you get those notices back, you file those green slips with the clerk, right? You need to show that you did serve them with the mail. And then the respondent's rights should be listed and attached to the notice of hearing. What I'll say is sometimes, again, this is where that collaboration with the clerk comes in. Sometimes clerks are going to coordinate with you and actually provide all of the information for the respondent to the GAL, and then the GAL serves the respondent. And so that's something that can work out. But every clerk kind of does it a little bit different. But I send anything that I'm sending, anything I'm filing, I am sending to all these parties, and it is just for their information. And that is, they're interested parties, bottom line. They may not participate, they may not even, they may just throw it all away, and that's fine. But they have a right to know what's going on. In the statute lists out these rights of the respondents to be removed. This has to be included in the petition if it's going to be any or all of these rights: the right to vote, dispose of property, execute instruments, make purchases, enter into contracts, hold a valid driver's license, give or refuse medical treatment, or any other legally advisable acts. So we want to be very, again, like, these are some major things that we're taking away from a person. You're listing those out in your petition. The petition also has to have financial information of the respondent, if known. And list of income, the amounts and frequency, the list of usual expenses and how they're met prior to filing. These ones are actually usually very easy for us when we're handling indigent clients, because if their only paycheck is Social Security, it's very small as it is, and in many cases, families covering the extra costs as it goes. So, and then a description of a proposed property management plan. Again, with indigent clients, it's much easier to include that in a paragraph or two within the petition. If you have someone who has assets and income, you may need to attach a separate proposed property management plan. Just identify what you're doing in the petition. You also need to request for a GAL. Obviously, the whole thing is to request a conservator. Make sure that language is in there. And if an attorney at litem is warranted, then request attorney at litem. Generally, attorney at litems are really are required if the respondent asks for one. If the respondent says, I want my own attorney, or if it's an emergency conservatorship, a attorney at litem is required. Okay. Here is our report of physician. I'm going to say the statute reads, so we have a longtime practicing attorney in the area who's advised us that the medical statement does not have to be notarized. And if you read the way the statute reads, the very first part, the first thing that says there has to be the report of the physician could be a report that has come from a medical exam that happened within 90 days of the filing of the suit. And it doesn't say anywhere about a sworn statement. But throughout the remaining part of the statute, it says sworn statement, sworn statement, sworn statement, sworn statement. And so I had filed one in a county here, and it turned out that chancellor requires now all medical statements be sworn. So I don't mess around with it anymore. I make all of my physician statements be sworn. And sometimes that means collaborating with the doctor to go get it notarized, because in these small towns, if they're just running a little clinic, they don't have a notary on staff. But it's just part of making sure that your proof is the proof necessary for getting these conservatorships in place. A licensed, Tennessee licensed MD or OD, DO. I don't know why it says OD, that was wrong. Not a nurse practitioner. Technically, the clerk is supposed to file all of the medical records under seal. Those are confidential. The rest of the matter is public record until it's all under seal, if that's by request. And the statement needs to include the medical history only within the examiner's scope of practice. If they're a general practitioner, they don't need to be given psychological evaluations. If they're a psychologist, they don't need to be given physical. And so if there needs to be more than one sworn statement entered into the record, then get more than one statement. In this report, there should be a description of the nature and type of disability, opinion of the treating professional, and any other matters that the court deems necessary. And if you can't get a report, sometimes maybe the respondent is refusing to go to the doctor or something, you can request a court order in your petition. So you don't attach the medical statement, but you do identify that you are requesting the court to order one. And any interested party, they don't have to be a named party to do this. Any interested party is allowed to request a second opinion or a second medical professional to evaluate the respondent. It is traditional to have that GAL order ready for the judge to sign. Again, confirm with the clerk what the preference is. We have one clerk where we just write what we propose the GAL on a Post-it note and stick it on the blank order, and so she can fill it in and sign it, and that works. Sometimes in advance, we're able to assign GALs. We have a pro bono program that can assign GALs, but just want to make sure in advance kind of what the judge preference is on those orders. Make sure in your order there's language that allows that guardian ad litem permission to discuss the financial institution and medical institutions, because they are going to be doing evaluations and they need rights to have access to those things. And then just confirm again with the clerk who's going to be giving the guardian ad litem the order and notice and stuff. Are you doing it? Is the clerk doing it? There's just a lot of back and forth with the clerk in these kinds of cases. Bond requirements. So the bond requirement is the sum of the fair market value of all personal property and amount of anticipated income from that property, and it's something that can be renewed annually. There's probably, I think there's 5 things listed in section B of the statute that the bond can be waived. And one of the things is if the respondent has less than $10,000 in assets. To be qualified for our services, in most cases, they have to have less than that. And so we almost always request the court waive the bond. And that's just because we have indigent clients who could legitimately not afford to pay to try and help their family member. But just be mindful that there is the bond requirement. Be upfront with that with the client when you're talking about them about the conservatorship process. But there are a couple of reasons why you could request a waiver. The court itself has need to keep moving on. The court itself has broad discretion to add requirements or to waive requirements. And I think it just shows the Tennessee legislature recognizes that disability cases are a case-by-case type thing. No disability is going to be the same. No person is going to be the same. Every situation is going to be different. And so judges have that discretion to be able to add requirements to make sure that everything's on the up and up, or to waive them. And so, like I said earlier, we often request to waive the bond. Depending for the annual accounting, if that client's sole income, if the respondent's sole income is Social Security, they're already required to submit a quarterly report to the Social Security Administration. And so many judges are willing to waive that requirement because rather than forcing the conservator to do 2 different accountings, as long as they're keeping up with Social Security, then that's fine. And the hearing itself needs to happen no less than 7 days and no more than 60 days from the date of service of the respondent. It can be extended on motion to show good cause. If there are situations, and sometimes there are life-threatening situations that can allow for hearing that happens less than 7 days, but actual notice of the hearing must be provided to the respondent and that closest relative. And these hearings are your opportunity to put on your proof. So you're going to want to set your question. If it's not contested, you're still going to want to put a witness on. Usually it's the conservator, because the standard in conservatorships are clear and convincing evidence, right? So that we need a clear and convincing evidence that the respondent has a disability and clear and convincing evidence that that person needs the court's assistance and protection. And so that's what this whole thing is. So you want to just kind of set up your questions of your conservator for the hearing, just kind of how long have you known this person? What is your relationship with the respondent? How long have you known the respondent? How do you care for the respondent? Are you willing to serve as conservator of the respondent? It gets a little more intricate when it is maybe challenged or if there's more parties involved. But generally a straightforward uncontested conservatorship case. These are the kinds of questions you're looking for. We're not done, but this gets a breather. I am running a little behind from my anticipated schedule, but I'm going to pause real quick to make sure there's not any questions. Andy.
So we have a couple of questions in the chat. One of them is, can an immigrant who does not have U.S. citizenship be a petitioner?
That's a good question. I think that's going to be, well, Andy, do you have an opinion on that one? I don't think so, but
to be a petitioner,
petitioner?
I think they can. To be the conservator,
Maybe not.
would be a different story that I'm not sure about.
Yeah, I think that's something that's worth like actual research. We've only had it, we've been able to work around that question, I guess, in our thing. Amy Bryant raised her hand. Can you let Amy talk?
She said yes to that question.
Okay, look, I'm letting her talk.
Okay.
Amy, is that
great,
okay?
I can talk. Hi. So I don't think there's a statutory prohibition for a non-citizen serving as a conservator nor as a petitioner.
Thank you.
That was going to be my question to you when you had it on the last slide. Can a U.S. citizen or a non-citizen not serve as a petitioner? As far as I know that they can. I know they can serve as a conservator. We've done it.
Okay. Well, good.
That's
What
not a
about,
question
have you ever done it
asked.
where there's been a respondent?
The respondent, I haven't had that to come up, but I can't think of a reason why. If I haven't seen it. It's
Okay.
not a question on a petition. It wouldn't be a question the court would ask. I can't think of a reason it would come up unless the lawyer brought it up.
Okay. We're very limited at West Tennessee Legal Services. Our clients have to be U.S. citizens. So that's where, but we had a situation where it's more almost like legal gymnastics, like where does the authority come from to be able to tell someone who's not a U.S. citizen? Okay, what's the next one?
The next question is, does your notice have to be certified? Doesn't your affidavit as an officer of the court comply?
Notice have to be certified. I don't think the notice has to be certified, but the notice is attached to your certified petition. Right? Does that make sense? Because I think, right, your affidavit as officer of the court would comply.
The next question is, in what situations would you recommend that a client seek a power of attorney?
But let me actually finish answering. When you say note, does that mean, does the notice have to be certified mail? What's that?
It says notice by
notice by certified mail. Yes, so that one, so you're following the statute, you're following the Tennessee civil procedure by service by mail. And so you'll fight clerks to the death, I think, over this issue. We've fought clerks over the death to this issue, like it has to be certified mail. Andy, have you experienced anything different? Or Amy, do you have anything to say on that?
So I have had some clerks actually say that it does not have to be certified and that you can just mail it because they're not the respondent. And then I've had others say that it has to be served like any other So I've had clerks.
I can follow up with you, Eric, if that's something, because the way I read it, I had an issue because I had a next of kin was actually in Mexico, and certified mail doesn't work internationally. So I had to basically kind of come up with go through the brief. And so it was my understanding that it does have to be certified or a form of certified mail according to the Tennessee Rules of Civil Procedure, but I could be just misinterpreting that. So Eric, if your judges don't care, then I guess then don't worry about it.
Eric just said the same thing.
I just do it to cover all the things. Yeah.
Mm-hmm.
So those websites where I see websites for checking, I think Andy's going to put those in the I sent those to him. There is all these websites that I've made reference to. There's going to be a reference list. Andy's going to put that in the Dropbox. In the
Dropbox already.
Oh, it's in the Dropbox already. Okay.
Yeah.
But those websites, so just look at those. It's just the DOJ's sex offender website, and if you just type in Google Tennessee Health Abuse Registry, that'll pull that up too. And those are all my questions.
No, there's one more. In what situations would you recommend a client seek a POA instead of
you read my mind. We're going to talk about that here in a minute.
Perfect.
Okay. Perfect. Okay.
That's all.
Thank you, everyone. I appreciate it. And thank you, Amy. And Amy, feel free to pipe in at any time, because I definitely feel like you're the guru and I'm merely just somebody out of West Tennessee just talking.
Well, I had one more comment. Felons cannot serve as conservators in Tennessee.
What's that?
Felons cannot serve.
Oh, felons. Thank you. You're not wrong. And I said that. Felons cannot be conservators, but people with misdemeanors can. Yes. Okay. So I appreciate you, Amy. Thank you. Oh, right. Here we go. All right. So just thinking through practical matters, can the respondent reasonably make it to the hearing? And if so, I want the respondent in the hearing personally. Like I want the judge is making a big decision over a person's life. So we think through just be aware of physical barriers of your courtroom. If you haven't been to the courtroom, maybe call the clerk and ask, hey, can a wheelchair fit in here? Or, you know, where should this person park? If there are emotional or mental barriers, call the clerk and again, explain the situation. Maybe kind of not just a new environment, but new people is overwhelming for your respondent. And so ask, is it possible that we can have this hearing first or last or be clear at the courtroom? And if it is something that does not, if this respondent doesn't need to be there, you can ask in your petition, but officially the GAL's report needs to say that and let the clerk know, right? The GAL is looking at the best interest as well and reporting to the court. If that respondent is unable to get there, maybe they're bedbound or homebound, or it really is just going to be too disturbing to have them come to this hearing, then just make sure that you coordinate that in advance. Practical matters. Have you spoken with the guardian ad litem or the attorney ad litem? You guys are, I mean, it is an adversarial proceeding, but you're still on a team kind of moving all this forward. And so you kind of don't want to maybe be shocked by a report that comes out, 2 days before the hearing, that you had no idea that the GAL had found these facts. When you're coming to the hearing, you want to bring copies of your orders. I generally bring alternatives if I know I'm going to request something. Like if I'm going to ask waive the bond requirement, I bring an order that doesn't waive the bond, and I bring an order that waives the bond. And the reason I do that is because I had one time I didn't have an order with me, and that ended up being kicked down the road so long, and it was just a nightmare. So I do what I can I just print out my alternatives and just be ready for the judge to say, these are what decisions I made, and I hand it to him. I bring a copy of the oath for the client to sign so that we just knock it all out right there. And I bring a copy of that inventory. And again, generally our clients, indigent clients, don't have a lot of assets. And so that inventory form is very easy for them to fill out. They might put, really clothes on their back, essentially, right? They've got $100 in the bank, clothes on their back, and that's their inventory. But it is a form that is required that they have to file. And so I don't forget about it. I just bring a copy with me, have the client sign it, notarize it, file it with the clerk. Well, I just talked about this a little bit, but your proposed order is going to name the conservator or co-conservators. It will enumerate the powers removed from the respondent. And those powers are specifically listed in the statute. It sets the bond requirement, or waives the bond requirement, sets the property management plan. If there is a reason that the person being appointed is not in the priority list, that needs to state it in there. And if there's any other determinations by the court, it also needs to be in the order. And then that oath, the oath is for once the conservator is appointed. I don't file it on the front end because they're not a conservator yet. The oath is once they're appointed, they sign it. They need to notarize it, so they can either sign it in front of the clerk or they notarize it and submit it to the clerk. If your respondent is a veteran, there is a whole title, or I guess chapter, section, whatever, in the Tennessee Code Annotated called the Uniform Veterans Guardianship Law, and it's kind of a national thing. Essentially, you have to notify the VA. They have stricter requirements on who's allowed to serve as a conservator, and there's a form the VA has to issue about the respondent. And it is essentially a form that states this respondent lacks the capacity to make decisions. So if your respondent is a veteran, there are some extra steps, and I just wanted you to be aware of that. If it's an emergency, you want to look to, there's the one statute, 34.1.132. If substantial harm is going to result to the respondent's health, safety, or welfare, if all of the requirements are followed, you can follow this. Emergency conservatorships are supposed to be limited in nature. They're not full conservatorships, and they are not to exceed 60 days. These are really just kind of special case-by-case situations. Oftentimes, they result because of maybe cases of abuse, cases where the respondent needs immediate assistance and is just not cooperating. And in these cases, it is required that the attorney ad litem is appointed. A guardian ad litem is not as required since there's an attorney ad litem. All three, you can have the petitioner's attorney, guardian ad litem, and attorney ad litem, but the attorney ad litem shall be appointed. The letters of conservatorship are your documents that show that you are the conservator. You have an order, but the letters of conservatorship are your authority documents. So they are supposed to be issued by the clerk. The way every clerk does it different. They can either list the powers in the letter itself, or they can attach the order to the letter. If it is less than a complete full conservatorship, it needs to be very obvious. It says limited, prominently featured on that letter. And this is the documents that show the conservator is the conservator, right? So this is a document that if the conservator can take to the bank or can take to the hospital. And the final order is not your final action. There needs to be an inventory filed within 60 days of the appointment. That's why I bring the inventory form. I let the client know this needs to happen. If it can happen that day, it happens that day. There's an annual accounting requirement, which I think is the most bizarre way to say this, but within 60 days of the 6-month anniversary of the appointment, so 7 months out, you have to submit annual accounting. And then from there out, every year, there's an annual accounting, and there's a form, like a worksheet, essentially, of saying this is how the money's been spent. If for some reason something needs to change in the conservatorship, maybe you need to modify who's going to be the conservator. Maybe you need to modify. If it were a partial, you're going to go full. If it's full, you're going to go partial. There's a procedure for modifying your conservatorship. There's procedures, there's statutory language for if you're going to transfer it from one county to another. Again, counties are supposed to be keeping track of open and active conservatorships in their county. And so this is supposed to, if a person moves, if the respondent is moving with their conservator, that needs to be noted in the court system. If a conservator is moving the respondent to another state, there is a whole proceeding that goes with that. And then termination is going to be required upon the passing of the respondent, or if the respondent no longer needs the conservatorship. And then any property sales do require court approval. Again, we don't deal with that very often because most of our clients don't have any property, but there is, I want you to kind of keep that awareness for what you're doing, that kind of moving forward, there's specific rules that follow sales. Setting your client up for success. So in these scenarios, mostly when I'm working these, I'm the petitioner's attorney. So my client is the petitioner / conservator. And so we want to make sure that we're not just helping them get this paperwork, but we're making sure that they can be successful conservators moving forward. Remind them of their legal obligations. There are in that Dropbox, I've made reference to this document before, but the weekly county clerk has this packet that has good information about what your duties are as a conservator. And again, that came from Rutherford County originally, is my understanding. But just remind them how to keep track of the money, keeping the money separate, keeping good records. Hook them up if they don't know with various organizations. So I know I saw Amy had posted, because I think that it's in the resources too, but where's the chat? Tennessee decision making, so some supported decision making organizations, the AAAD office in your area. The Conservatorship Association of Tennessee is designed not just for attorneys, but for anyone that's involved in the conservatorship process. And then just be mindful that once the respondent passes away, the conservator has a responsibility to file the final accounting. All right, I'm gonna have to breeze through these a little quick, and I'm very sorry that I'm having to rush here at the end. So the guardian ad litem, in the cases of a conservatorship, the guardian ad litem is required if that conservator is going to be serving as a fiduciary. Again, there's technically that waiver that judges are allowed to waive. One of the things is if the respondent has counsel, then there doesn't need to be a guardian ad litem. Like if an attorney ad litem has been appointed. If the conservators are parents, There's a couple of other little options that are kind of more relate to guardianship situations. But essentially, if a judge says it's in the best interest of the disability, they don't need the GAL. It's not it's that discretion is up to the judge. The GAL's duty is to impartially investigate and make a report and recommendation to the court. They're not advocating for the respondent. They're not advocating for the family. They're not advocating for the petitioner. They are more or less just impartially investigating the situation and making the report to the court. This is what's happening. So what should happen, they really should verify that all the parties were served. So I know we had some like discussion on how people get served. The guardian ad litem should ensure that those parties got noticed, however that is. They should go and interview the respondent. This party needs to lay eyes on the respondent. And if possible, in the way the statute is written, in language understandable to the respondent, ensure that you're describing the substance of the petition, the nature of the proceedings, that respondent's rights to protest, the rights listed on the notice, and who the proposed conservator is. Every situation is going to be different. That's going to look different depending on who you are. But that's your responsibility as the GAL. And then you're investigating kind of the finances and the medical reports. You need to report whether a fiduciary is necessary. Is this conservator going to serve as a fiduciary as well as the conservator over the body? And include that in your report. Detailed description of if there's mental or physical conditions or both, and how those conditions impair the respondent's ability to function. Include if respondent wants to contest. If the respondent has indicated they want to contest, GAL needs to let the court know that's the case. Include proposed management plan. If review it. If it's agree it's appropriate, or I'll propose an alternative. And identify whether that respondent is going to attend a hearing, or if it's not in the best interest, make sure you let the court know why. The attorney ad litem is, again, this one, so these are very rare in conservatorship cases, but they're very important. The attorney ad litem advocates for the respondent itself. They're required in emergency cases. And the attorney is their duty is for the respondent in resisting the requested relief. Now, there's no language in the statute that explains how the attorney ad litem is supposed to represent. And if you look at, I want to say it's elder law, it's some conservatorship guide. They had like 3 different ways an attorney ad litem could potentially present, right? Like, are they supposed to present as if they were the respondent? What would they want to do? Are they looking merely at the respondent's request? Are they 100% adversarial in this whole proceeding and resisting all things conservator? What is their role? But there's not really anything kind of written in stone on what that looks like. So again, I think it really just depends on case by case, what's going on in the situation, that you use your experience and your knowledge to come to the situation and just make sure those respondents' rights are protected. And in this case, attorney ad litem, the fees are charged against the respondent. And that doesn't look like there's much change waiving on that one. So thinking through ethical considerations, who is your client? And these, again, can be kind of murky when like families trying to step in and help, when it's maybe, it's a son or daughter of an aging parent. But who is your client? And what happens when there are multiple family members involved? Is there an actual conflict, right? So if this is an adversarial proceeding, have you previously served the respondent, and kind of be mindful of that? So I have these just kind of thinking through it. Is the petitioner your client? Is the respondent your client? The GAL isn't necessarily have a client. They're investigating the situation again and reporting to the court. But make sure you as an attorney identify who you owe your duty of competence, diligence, confidentiality, and loyalty to, right? So there's lots of moving parts. yeah, there's lots of moving parts. But just make sure that that person, that you know who your person is, that your client is, and that your casework is for that client. This one, I think this was the question that someone had asked a little bit. Well, yeah, alternatives. This slide and the next slide are going to answer a little bit about as far as power of attorney goes. But I want to be mindful of capacity. And I think it's just be mindful of that ageism exists, right? In just inherent biases. Ageism and ableism exists. There's just kind of, maybe society assumes that because someone's aging that they have a lesser ability to do things. Someone has a disability that they have the lesser ability to do things. And that's not necessarily always the case. And just be mindful of good intentions from caregivers. I think sometimes caregivers want to do for the person they're caring for rather than allowing that person to do for themselves. I also think a lot of times we have situations where a family member wants good things to happen for the respondent. But if the respondent has the ability to make their own decisions on things and they're making bad decisions, it does not mean a conservatorship is appropriate. It is heartbreaking, it is unfortunate, but it does not mean that we need to take this to court and legally strip that person of their rights. And so that's where we just kind of have to be mindful of those good intentions of caregivers. And don't be afraid to tell the person, you know what, you need to take this, take this to the doctor before, and then come back to me. We're not medical professionals. Maybe you are, and that's amazing. I feel like the law is enough, but maybe you're a medical professional. Be aware that physical conditions may impact mental abilities. Like I mentioned earlier, UTIs are a classic situation for aging individuals. They present as if that person is losing their mind. And it can be scary, but give them some antibiotics and it's straightened out. So you just want to make sure you're kind of dealing with that, addressing with that. With this alleged disability, is there, just be kind of make sure you're getting the full picture. Is this something that's ongoing? Is it something that's going to be fixed? Is it something that's going to be rehabbed? Don't be afraid of getting a second opinion. Hey, go to your primary care physician and a psychologist. And then what happens if capacity comes and goes? And I think this lays into our second with that question, and kind of what my next slide is going to be, thinking through alternatives. The capacity to sign a power of attorney is that of if you think that person can enter a contract. So a lot of times when clients call in and I'm just trying to kind of feel out, is this necessary for a conservatorship? I'll ask, do they have good days or bad days? If they have good days where, they're on the up and up, they know what's going on, they remember things. But sometimes they do have bad days where they're just kind of lost mentally. Conservatorships aren't appropriate. They're still functioning. And you're just going to need to collaborate with individuals, maybe whether it's the nursing home or that family member, to catch them on good days, to issue that power of attorney. You also maybe need to document all of that for your own sake. What's going on? Does this person have capacity, and why you think they have capacity? Limited conservatorships might be an option. So that's where I try to make sure, we always start with, this person does not need a conservatorship. What are our options outside of conservatorship before we move to conservatorship? Can this person execute? Do they have the capacity? Even if it's only between 8 a.m. and noon, the only time that they're really functioning. Afternoon, they really start just kind of slipping, then that's fine. You want to catch them because you don't want this heavy, this very serious thing. But there are also limited conservatorships. Maybe they only need assistance. They only need your help in medical decision making. They only need your assistance in, everything else is taken care of is just automatically going through the nursing home or what have you. So just be mindful that there's options. You can tailor your conservatorship to make it limited in time, in person, and purpose, and in scope. If you suspect abuse and there is already a power of attorney in place or a revocable trust in place, You can actually file to remove an agent and replace an agent. So you don't have to move forward with a conservatorship itself. You can request the court, and there's statutory, so that this statute is in the power of attorney area, but if you dig in, there's ways that you can request if you think that there's like fiscal abuse, like financial exploitation happening. You can request the court challenge the fiduciary to present, show me how you're spending the money, and you can request the court to remove that person as an agent and replace the agent. And so you don't need to put in a conservatorship. If they already have a power of attorney in place, you can ask the court to go ahead and just have this come in place instead. So I feel like that was kind of a water hose approach to giving you information about conservatorships. And if you have any questions, I am happy to answer them. I will get back to you as soon as possible, but you can email me. If you want, I put Andy, I don't know, I didn't ask Andy if I could put his email on here, but I did. So if you have questions about a pro bono program, or wanting to step in, or you can't find me, you can get Andy. He'll come down the hall and bother me. He'll do it without asking too. So, but with that, I'll say if there are more questions, or if I didn't answer your questions enough, now is a good time, because I think we have like 3 minutes.
Yeah, there's no questions in the chat.
And I want to say shout out again to Amy. Amy is a huge resource. Amy, are you in charge of the Conservatorship Association of Tennessee?
No, I'm just the president of that. I'm the director for the
president.
Office of Conservatorship Management.
And there's still, as far as I know, I thought I heard from you last week that there's still no state oversight of conservatorships in Tennessee.
That is correct. But tell all your friends we need it. I want it.
We do. I know. This is why we're doing this. We keep saying stuff. So, and next month, November, is an all-day. There's CLE training available in Nashville through the Conservatorship Association of Tennessee. Is that right?
That is correct. And it's also virtual. I can send you the flyer if you want to share it.
I will. Yeah, we'll put that in our resources. There are public conservators. I see, Eric, your question. So the public guardianship program in Tennessee is limited to people over the age of 60, and in very, very unique cases, special cases, if they get permission from the Commission of Aging and Disability, they can take cases where the respondent is under the age of 60. But it is still a very limited program. And so it is something, I don't think there's just not it is a need, right? Getting a bigger, maybe, program in place as far as public conservators go. I think there's just maybe a handful of like companies that can potentially serve as conservators, but it's just not really anything widespread. Yeah, not anything widespread.
Nonprofits. There's one in Gibson County, as well. And Vanetta asked a question. There will be a recording of this. It might take me a minute, since I will have to put 2 videos together since we had the interruption. But it will be posted on our YouTube and sent out to everyone who registered.
Amy, are we allowed to give your contact information?
Yeah, somebody just asked for it in the chat.
Yeah, and I can put it in the chat too.
Okay. Sorry, I didn't mean I was going to contact you in advance and tell you I was putting you on the spot, but I was like, she seems cool.
I'm a public servant. I'm here.
I was like, well, I went to your session at EJU last year, and then I couldn't make it this year, but yes, okay. So, and then as far as secondary sources, there is I have it printed off. It's gonna take a minute to get it. It's basically contained in the elder law. There's an elder law treatise. There's a whole chapter on conservatorships in Tennessee, and it breaks down things I think really well. That I don't know if that's something I'm allowed to share like publicly, because it's technically, but I can at least share what the resource is. Andy, I will get that to you to put on the Dropbox by the end of the day. It's a good question, Elena.
Then really quickly, I know we're at 11:30. If you have any more questions, put them in. But for our purposes, for West Tennessee Legal Services, if you are interested in taking a pro bono conservatorship case, we do actually have on top of the forms we actually do have document automation software as well, that all of our volunteers will be given to use, where they can automatically generate almost all the forms that are needed to file a conservatorship. We try to make it as easy as possible for all of our volunteers to be able to take cases without spending too much of their time. So like I said, if you're interested on the form to get a CLE, to get your CLE credit, you can sign up to volunteer and I can reach out to you. But if there's no other questions, I know we're a minute past time. You can reach out to myself or Elizabeth, and
Or Amy.
we continue to update that Dropbox with more resources as Elizabeth sends them over. I will also put, Amy has sent the information about that conference. I will put that in the Dropbox as well for anyone who might be interested in registering for that.
Yeah, but thank you for attending. We appreciate you.
Yep. And like I said, I will get the recording of this out either tomorrow or Monday. So you all have a great day. We are also doing another CLE on October 25th. You can register online, and it will be 1 hour free ethics credit. But if anybody has any questions, you can just let us know, and y'all have a good day.